Yep, we are recording.
Great. Welcome everyone to part 1 of 4 of our eviction training series, Understanding the Eviction Process. My name is Shep. I'm an AmeriCorps with AmeriCorps Legal Advocates of Massachusetts. I'm currently serving at the Justice Center. Looking forward, we have 3 more trainings in the next 3 weeks. Tools for facing evictions, tools for tenants facing evictions, rental assistance resources, and then finally navigating the eviction process and accessing resources. Before I start my presentation, I'm also here with attorney Laura Camara, who's a senior attorney in the Housing and Benefits Unit at the Justice Center, and she's gonna just talk to you about the goals of this training series as a whole.
Good afternoon, everyone. Thank you so much for joining us. It's so nice to see so many familiar faces taking the time to join us today. So the goal of this series really is to arm all of you for what we anticipate to be a surge of evictions in the coming months. We anticipate that many of the resources that have been set up to deal with evictions in the past are going to be overloaded, and that many of our clients and your clients are going to be looking for answers. The goal of this training series is not to have you all replace us as the providers of legal services. That is still our role. The goal is to arm you to know where to best send your clients for the help that they need, and to best identify where they are in the eviction process so that you can help guide them to where they need to be as quickly as possible. We know that you all have your own roles and are overworked already, and so the goal here is to provide you information to quickly and easily identify what is happening in somebody's situation and where to send them for help. So that we can all work together to try and face what truly is going to be a crisis on top of a crisis. So thank you so much for joining us. As Stephanie said, we are going to be recording the body of the training, but we will not be recording the chat or the Q&A. I will be manning the chat for the duration of the presentation. I may hold some of your questions to the end if I do think that it's something that is really important for the group. But for questions that maybe are more tailored, I will be responding in the chat as we go along. We're also joined today by 2 other attorneys with the Justice Center, Stephanie Heron-Rice and Head Ehrlich, both of whom I think are going to say a quick hello.
Hi, everyone. Just welcome. It's nice to see your faces, even if it's this small. And we're happy to have such amazing partners. This is going to be a hard time for our clients, and we're here to fight alongside you for their rights. And so thank you for your work. Thank you for being here. And thank you for your commitment to our clients, the most vulnerable of the Commonwealth.
All right, well, thank you. And without further ado, I think Shep is going to proceed with the training.
Great. So today's goal is to provide you with information about the eviction process, or it's also known as the summary process, or the legal rules governing evictions. Technical difficulties already. Concretely, we'll be looking at 4 things. 1, eviction basics, and under that, reasons landlords can move to evict tenants, and then a general timeline of evictions. Second, we'll look at recognizing types of evictions. And then third, I'm going to talk a little bit about COVID-19 changes to the court process and how that's impacting the flow of evictions in Massachusetts. And then finally, we'll look at a few of the documents that are used in the eviction process with the goal that you'll be able to understand the kind of most important information in them. First identify them, understand the most important information in them, and then help clients interpret them. There are 4 reasons a landlord can move to evict a tenant. First, if a tenant does not pay rent, that's known as a non-payment eviction. Second, if a tenant violates the tenancy or lease terms, this is known as a cause eviction. Third, if a tenant is at will, meaning they don't have a written lease, landlords can evict for no reason. This is called a no-fault eviction. And then finally, if a tenant has a lease that's ending and the landlord has substantial grounds to believe the tenant will not leave, the landlord can move to evict a tenant. This final type of eviction isn't very common. It's unlikely that you'll encounter it, so I'm not going to go into any more detail. We're going to focus on the first three. So generally speaking, if a landlord wants to evict a tenant, the landlord has to go through the courts and they have to follow a timeline that's laid out in the law. And this timeline starts with what's called a notice to quit. This is a document that explains when the landlord wants a tenant out and why. The notice to quit will list an expiration date. This is the end of the tenancy, but it's important to note that the tenant doesn't have to move out at the expiration of the notice to quit. It just states when the landlord can begin the sort of court portion of the eviction process. Following the end of the tenancy, a landlord, can serve a tenant with a summons and complaint. And then 7 to 30 days after that, the landlord can actually file the summons and complaint with the court. Now, under COVID-19 rules, things are a little bit different. Normally, the summons and complaint would state a date for the trial, but now the court is actually going to follow up with a notice that tells both the tenant and the landlord when the court events are, and the tenant's answer in discovery is due 3 days before the first tier event, which is a mediation to be scheduled by the court. If an agreement, this is going to be held via Zoom, it's all virtual. If an agreement isn't reached, then a second court event will take place at least 2 weeks after the first. The court will again schedule this and send both parties with a notice. Assuming that the tenant attends trial, oh my goodness, keep making the same mistake. The judgment can enter as early as 1 day after the trial. If it's a jury trial, it has to enter 1 day after the trial. If a judge is making the decision in the case, then the judge can take as long as they want to make a judgment. They make their judgment, and then the decision enters 1 day after they make their judgment. What follows is then a 10-day appeal period where both parties have a chance to make their appeals. If an appeal is entered, then all movement in the case stops and until the appeal is heard, which could be up to a year. Assuming that an appeal doesn't happen and the judgment enters against the tenant, meaning the tenant loses the case, then the landlord is likely going to serve, well, the judgment executes and the landlord is likely going to serve the tenant with a 48-hour notice to move out. And if at the end of the 48 hours, the tenant doesn't move out, a sheriff and or a constable can come and place the tenant's possessions into storage and move the tenant out. As I said earlier, there are 3 types of evictions: non-payment, cause, and no fault. Non-payment, again, is if a tenant doesn't pay rent. It comes with a 14-day notice to quit. An important note is that under the CARES Act, there are some properties entitled to a 30-day notice. Then for tenants at will, they have 10 days to cure the notice by paying off their rental balance. That's any arrears or back rent they owe, plus current use and occupancy. For tenants who have a lease, their cure period extends to the answer date, which again is 3 days before the first trial event. Tenants facing non-payment evictions can raise both defenses and counterclaims in their answer. This is distinct from a cause eviction, where a tenant can only raise defenses in their answer. For a cause eviction, tenants at will have 30 days, will receive a notice to quit that expires after 30 days, or a rental period, whichever is longer. And this notice to quit must terminate on a rental due date. A tenant who has a lease will receive a notice to quit that's in accordance with the lease. Whatever the lease terms are, is the amount of notice they'll get if an alleged violation of the lease occurs. Finally, in a no-fault case, which only applies to the tenants at will, tenants who don't have a written lease, they'll receive a 30-day or rental period notice to quit, which again, terminates on a rental due date, and tenants can raise both defenses and counterclaims in their answer. Many of you might have heard about the CDC eviction moratorium. It's a moratorium on COVID-related non-payment cases running from September 4th, 2020 to December 31st of this year. It came into effect in Massachusetts on October 18th with the end of the more strict moratorium on evictions in this state. Under the moratorium, to receive protection, tenants have to be eligible, and they have to, they have to be able to say yes to the following 4 or 5 statements. 1, that they're unable to pay rent due to lost income or medical expenses. 2, that they expect to make less than $99,000 individually or $198,000 as a household, and or have received a stimulus check or did not file a tax return in 2019. If any of those 3 are true, then number 2 applies to them. 3, they have to have tried to obtain government rental and or housing assistance. They don't have to have obtained it, they just have to show that they tried to obtain it. 4, they have to show that they're using their best efforts to make timely, partial, and what is affordable to them rental payments. And number 4 applies because the eviction moratorium doesn't actually waive rent owed. It just prevents landlords from evicting tenants for non-payment. And then finally, if evicted, they have to show that if they were evicted, they would become homeless, need to move into a homeless shelter, or need to live with family or friends in an overcrowded dwelling. If a tenant believes they're eligible, they have to sign a declaration and deliver it to the landlord to gain protections under the moratorium. And every adult on the lease should sign a declaration, deliver it to the landlord. A couple important things to note. 1, the moratorium doesn't cover cause cases. 2, the court is also taking the position that the moratorium doesn't cover no-fault cases. But if a tenant is facing a no-fault eviction and they owe rent, they should see if they're eligible under the CDC moratorium and also should be referred to legal services. Before I move on to talk about COVID-19, the court process under COVID-19 rules, we're going to do a couple of scenarios just to kind of go over some of the information you learned, or hopefully learned. So we'll ask you to type some answers to these questions in the chat box. They'll give you a couple minutes to respond, and then we'll go over the answers. Scenario 1 is that a client calls and says they just received a document that claims they violated their lease because they live in a building that doesn't allow pets but own a dog. Question 1 is, what kind of eviction is the client facing? And question 2, how does the client know when the landlord can serve them with a summons and complaint? Go ahead and put your responses in the chat box. Unfortunately, I cannot see them, but.
Tenancy preservation, quick off the draw. Nice job, Marlise.
Great.
So they definitely got question 1. Can anybody answer question 2?
How will the tenant know when they're going to get their summons and complaint? Anybody have any thoughts?
Might be kind of tricky. Any good responses?
Yes, we're getting some great responses. So why don't you go ahead and go over the answers? But we definitely have some people who are listening or already knew.
Great. The answer to question 1 is they have that they are facing a cause eviction. And then question number 2, the answer is that they should read the notice to quit. It should be 30 days or a rental period if they're at will, or whatever is written in the lease if they have a written lease. However, a good rule to follow is that if there's even if the date for the expiration on the notice to quit is incorrect, the tenant should assume that the landlord is using that date as the date that they can summon or serve the tenant with a summons and complaint, and that's the date that they're going to start moving forward with the court process. And they can deal with any improper notice to quit later on in the process. So scenario 2, a client just received a notice to quit because they've been unable to pay rent in 2 months. What do they have to do to cure their eviction? And then how many days do they have to cure the non-payment and stop the eviction?
Tenancy preservation, again, making a strong showing.
Sorry.
Yeah, great job, everybody.
Great. Do you think we can go ahead and...
There was a good question sent to me privately. It says, can clients still file the CDC declaration form if the landlord's attorney has already filed a motion to issue execution, and in that motion explained they did not receive the declaration? The answer to that is yes. Tenants need to give this declaration, if it applies to them, to their landlord to stop a non-payment eviction at any point.
So at any point until they are physically moved out, they can provide the landlord with that declaration, and it should stop the process in its tracks.
Until the CDC moratorium lapses on December 31st. Sorry to interrupt, Shep.
Oh, great. Thank you. The answer to the first question, what do they have to do to cure their eviction, is they have to pay arrears or back rent and current use and occupancy. And then the answer to question 2 is how many days do they have to cure the non-payment and stop the eviction? If they're at will, they have 10 days. And then if they're a tenant with a written lease, they have until the answer date. I'm just going to talk a little bit about what a tenant can expect from the court process under COVID-19 rules. Due to the COVID-19 emergency, the majority of court events are now virtual. They're going to be conducted via phone or Zoom. We understand that that is an incredible barrier to low-income folks. So we urge anyone who thinks that they'll have trouble attending trial because everything is virtual to inform the court as soon as possible, either by calling or going in person. If they don't have a phone, the courts are open and they can go. And the court has a duty to ensure people can actually attend their trial despite any technical issues they might have. The summary process cases can be filed in either the district court or the housing court. Both courts have announced new plans for addressing the summary process cases. The plans both kind of look the same, but are slightly different. In the district court, the first virtual court date is with a clerk who provides information and asks questions about how the case will proceed. For example, if the parties want to settle. And then if no agreement is reached in the first event, the case moves on to a second event, which is the virtual trial. District court, with regards to the CDC moratorium, the district court isn't moving forward with cases with CDC moratorium covered tenants, which is a lot better for tenants than what's happening in the housing court, or maybe might be better for tenants because the housing court's still litigating to the end, and they're only preventing landlords from moving tenants out, physically moving tenants out of the unit. In the housing court, the trial or the court dates kind of follow the same pattern. There's a first virtual court date with a housing specialist who's a mediator who provides information to both parties and tries to settle the case. If that doesn't happen, the case moves on to a second court date, which is the trial. Okay. This final section will talk about identifying eviction documents. I'm going to start with the notice to quit, which, as I said earlier, is a document that tells a tenant why and when a landlord wants them out of a unit. It'll say whether the eviction is for non-payment, cause, or no fault. It'll also state the number of days notice that a tenant has. Typically, this is 14 days, 30 days, or one rental period. But again, that might vary, and a tenant should just assume that the notice expires when it says it expires, and then any issues with the notice to quit can be dealt with later on in the process. It's also important to note that there's no standard notice to quit. Tenants have to read the notice to determine the type of notice and when it expires. That said, we're gonna look at two examples of notices. First, a cause notice, and then a non-payment notice. Here's the cause notice. I underlined in red all the kind of important information I talked about. So it says that this notice is due to a non-compliance in the lease agreement, meaning someone is alleged to have violated their lease. And then it goes on to specify what that violation was, that a person who's not listed on the lease is living in the apartment. And then finally, I underlined that it's a notice for 30 days. So generally, the notice will say, if it's a cause notice, it'll say what the violation was and then how long the tenant has. And then here's an example of a non-payment notice. It says very obviously that it's for a non-payment. And then where this notice says number, it would have the total number of days notice that the tenant has. And then it'll also state the arrears or the total amount that they owe, which again is arrears plus current use and occupancy. The next document that I also talked about earlier is a summons and complaint. And this is a document starting the eviction process, or the court portion of the eviction process. The landlord can file the summons and complaint between 7 and 30 days of serving the summons, or serving it to the tenant. This is a standard document in Massachusetts. Landlords have to purchase a copy from the court. This will list the dates of service and entry and the reason for eviction. And under COVID-19 rules, the summons now states that the court will follow up on the summons with a notice providing the hearing date. And the answer date is 3 days before this first hearing date. Here's this, the example of the summons and complaint. The front, again, will state the defendant's name, the landlord's name, any money or arrears owed, etc. And then the back is just proof of service. Finally, I'm going to talk about the answer and discovery. This is basically the tenant's response to the summons and complaint. It has two parts. First is the answer, which are the tenant's defenses against eviction and any counterclaims they have in non-payment and no-fault cases. The second portion is the discovery. It has 3 parts. The first are questions or interrogatories that the tenant wants the landlord to answer under oath. Second are requests for documents related either to behavior the tenant has is alleged to have engaged in, or that would be helpful for any of the tenant's defenses and counterclaims. And finally, the third portion is the admissions, which are statements that the landlord has to respond to with either a true or false. Tenants representing themselves can use the made plain language form to create answers and discoveries. We're going to actually have a training on that next week. This is offered on the Greater Boston Legal Services website at www.gbls.org/made. It's a really, really good resource. The answer and discovery are, again, due 3 days before the first court date.
I'd just also add that in addition to the answer and discovery, any jury demand is also due 3 days before the first event. Tenants in Massachusetts have a constitutional right to a trial by jury in an eviction case, and we strongly discourage people from waiving a constitutional right without first talking to a lawyer. Using the MAID system, tenants can also assert their jury demand, as well as using the mass legal help forms that we're also going to go over in the next training.
Great, thank you, Laura. And then here's just an example of an answer and discovery that I created using the MAID website. Again, we'll have a training next week, but it's also really helpful to just go on and kind of try filling it in yourself to get a sense for how it works. Okay. And then we'll do a final scenario. A client comes to you with a paper that says summary process, eviction summons and complaint at the top. Question 1 is, what information can you expect to find on the document? And question 2 is, where can a client go to create an answer and discovery to submit to the court?
And just with the last ones, you can all put your responses in the chat.
Again, I can't see if there are any responses, but the answer to question 1 is that it should say the defendant's name, the date of the hearing, that the date of the hearing is to be determined and will be sent to them later by the court. And then it should also say the reason for the eviction. And then, the answer to question 2, where can a client go to create an answer and discovery to submit to the court? MAID. And again, because I haven't plugged it enough, we have a training on that next week. With that, are there any questions? Which I think Laura will respond to.
And these can be questions, about the eviction process generally, questions about the CDC moratorium, questions about, operations in the housing court. So if anybody has questions, feel free to unmute yourself and ask, or to put them in the chat. So we just received a question in the chat. Can a declaration be served to a property manager? So yes, they are the representative of the landlord, and they absolutely can be the recipient of the CDC declaration. I would add, though, that we are strongly encouraging any tenant who does provide their landlord with a CDC declaration to, 1, keep a copy and keep proof of how they delivered it,